My name is Victoria. I am one of the attorneys with the Kopenberger Law Firm. One of the things at Kopenberger that we really strive to make sure is done is education for clients, especially when it comes to legal changes that have occurred that you may or may not be aware of. One of the biggest changes in the last year was changes to Medi-Cal rules. So in 2024, Medi-Cal fundamentally changed how people are able to or not able to qualify. And with that, there was a change in what tools are available to assist you in that qualification. So we want to take today to make sure that you understand what has changed, what options are available to you, and how this may apply to you directly or to somebody you know. Now, we want to be clear, this is obviously for education purposes. For any specific questions, specific guidance, it's very important that you come in and set up a specific appointment to make sure we're addressing your needs as you actually have them. Now, if you either don't know Kopenberger or it's been a while since you have seen us, I want to quickly take a moment to go through who we are. So these are our attorneys and officers. Now, not only is this the team of attorneys and officers that we have, it's also important to note that we have multiple departments at Kopenberger. So we, of course, have our estate planning department, which is where we focus on setting up a plan to make sure your wishes are carried out, whether you're incapacitated or after you have passed away. But we also have a number of other departments. We have our business and tax department, which is focused on business and taxes. So that could be LLCs, you have a rental property or a small business. It could be larger businesses, maybe you have tax questions. All of those things can still be handled in-house. We also have our estate administration department. So at some point, we know we will all pass away. And so the administration department is there to make sure either your estate plan is carried out so that your wishes are actually carried forward, or if you didn't set up a plan, that they go to court for your executor and ensure that that process is done as well. Now, a lot of what we talk about is how to avoid court, but unfortunately, sometimes that is an inevitability, whether we have done planning or not done planning. And so we also have our estate litigation department, which is there to ensure that you have representation or your loved ones have representation if or when that time became necessary. We, though, as attorneys, could not do what we do without our incredible staff. So our staff is the reason that we are able to help so many people in so many different ways. So when you work with one of the attorneys, you also will work with a number of our staff as well. We have offices all over the state of California, but we also can meet with people via Zoom or over the phone. So if one of our physical locations is not actually close to where you live, or you have a family member that you want to talk to us, we can still again meet with them virtually. All right, let's dive in. What has changed? What has Medi-Cal done? So, a little bit of background. Medi-Cal used to look at somebody's assets to determine if they had a physical need, did they also have the ability to qualify financially? That asset threshold went from $2,000, which was abysmally low and essentially meant nobody could qualify, and then it jumped to $130,000, meaning if you had under those markers and you physically needed some advanced care, Medi-Cal would allow you to then qualify and have them provide some amount of financial assistance for your advanced care needs. But then in 2024, about middle of the year last year, they fundamentally changed the rules and no longer look at assets when determining eligibility for some of these programs. They will now look at your income. So what does this mean? Well, for one, it means a lot of people who maybe have lower income but higher assets, like for example, if you have larger savings accounts, you had stocked it away while you were working, but you're no longer employed. Your income may be significantly reduced, but your assets may be much higher. Well, now they won't look at those assets. They will look at what your monthly income is. So again, this has opened up Medi-Cal for more people than maybe they realize. A lot of people that we talked to had been denied by Medi-Cal under the asset rules, but now have the possibility of qualifying under income rules. So again, that was a pretty fundamental change that just took place. So what income is counted? All of it. Anything that you can report as income on your tax returns will be considered when you're looking to qualify. But not all of this income has to be counted. So really quickly, when Medi-Cal is looking at your income, for an individual, they're looking at just shy of $1,800, and for a married couple, about just over $2,400. Now, this number shifts each year, so this is an up-to-date number for 2025. For some people, they may still be over this monthly income limit. For others, though, you might take a look at this number and say, oh, actually, if I needed Medi-Cal, I'm already under that income limit, which would mean you could just qualify for Medi-Cal if you also have a physical need. But what happens if you are above that limit? We'll go through a couple of case studies at the end, but essentially what it means is if you are over their limit, even by $1, Medi-Cal says you can keep $600 of your monthly income, and the rest would be subject to what is called a share of costs, essentially meaning anything above than the 600 would now be needed to be spent before Medi-Cal would kick in. So for some people that are above this limit, which is quite a few of the people we meet with, now their concern is, well, if I'm already going to have to pay a vast majority of my income, what is the point in attempting to qualify for Medi-Cal? So that's the stuff we really want to address today. Now, I mentioned Medi-Cal does not have to look at all of your income. So there is certain classifications of income that can be protected. Generally, we can set up protection planning that can preserve your income for all except retirement. So if your only source of income is Social Security, IRAs that have required minimum distributions, 401ks, any of those categories, unfortunately, cannot be protected with what I will be discussing today. But if you have rental income, if you have dividends, you have things that are other sources of income beyond retirement, there are planning tools available where you can preserve that income and still receive assistance from Medi-Cal. So the trust that we're really talking about at this point is called an OBRA 93 trust. The purpose of this trust truly is to protect your income. So for certain clients that we will meet with, they will have, let's say, Social Security and rental properties. Those rental properties produce an income, and that is income that for most people without this would then have no way of qualifying for Medi-Cal, or at least the benefits would not be very high because the amount they'd have to pay for their own care at that point eclipses what Medi-Cal would kick in and do. But for those with an OBRA 93 trust, this now becomes a tool in which they can preserve that rental income, which often is needed to take care of the healthy spouse, to be socked away so that it can provide for those rental properties if anything comes up, or to provide just for your basic needs, or if the other party becomes unhealthy on a temporary basis. Obviously, we like our income. There's a reason often that we need it. And a lot of times what we unfortunately see is without protection and without these tools, you end up spending everything that you have to take care of the unhealthy spouse and really have nothing left to take care of the other party. Or you end up depleting everything if you're a single individual and you're not able to then leave something behind if you have kids or other loved ones that you would wish to have something when you're gone. So again, these protection tools allow you to not only provide if you have a healthy spouse or someone else who's reliant upon you financially, or if you're looking to leave something from a legacy standpoint. So who should look into these OBRA trusts? Well, if you are a senior or frankly, any individual where you have income that exceeds the Medi-Cal limits and you have a physical limitation or you know that one is coming, in some cases because of genetics or an early diagnosis, we know that something will come down the line that is going to end up costing in true dollars and cents quite a bit. So if you're in that position, you should absolutely come and talk to us. Families who are seeking to, again, preserve a legacy. You don't want every single dollar and penny that you've earned dumping into care when you could get assistance from a program you've already paid into anytime you pay taxes. And if you're already someone who is looking at needing long-term or advanced in-home care, it is imperative you talk to us before you lose the capacity to do so. With estate planning, one of the primary concerns we have is ensuring people have either the capacity to tell us what their intentions are, or they've already set up protection in place so that when they lose that capacity, we're not in an emergent or unfixable situation without court assistance. Again, everything I want to talk about is how to avoid court being needed. And so much of that comes down to pre planning for these different life events. So, again, are you somebody who needs to talk about this today, or is this information that you can kind of funnel away to pull out at the time it does become necessary? Do you have rental properties? Do you have investment accounts that produce a high income? And ultimately, do you want to avoid the state or estate recovery after you've passed away or during the time that you need advanced care? If any of these apply, then come in and see us. Worst case scenario, you spend some time with us getting additional information, but you walk away and you don't need the planning today. Best case is you come in proactively and we're able to get you set up before anything affects you and before we're in an emergent situation. Now, with the OBRA 93, that again is really focused on Medi-Cal protection and protecting your income. But it is imperative that you do still have a revocable living trust. If you already have a revocable trust, one of the things that we would do is see, does it need to be updated in any way to correlate with the OBRA 93, or is it fine as it stands? If you do not have a revocable trust, again, it is imperative that we still have one set up. The revocable trust is really making sure that your assets completely avoid probate, and it helps simplify asset distribution after you are gone. So they end up having different goals that can, again, correlate, but do not supplant the other one. Most people who have an OBRA 93 will also have a standard revocable living trust. So again, if either you already have this, you would end up very likely with two trusts. If you don't have a revocable trust, know that again, you would likely walk away with both. Now, trusts, though, are not the only thing that we want to ensure that you have in place. You also need to make sure you have an up-to-date durable power of attorney. Now, I want to emphasize up to date. As of now, durable powers of attorney, which is the financial power of attorney, have to be done every 5 years. If they are not, a lot of financial institutions are rejecting them as being out of date. That is the financial institution's way of attempting to combat financial fraud and elder abuse. But it has led to some huge issues for people who don't realize that, end up incapacitated, and their power of attorney is not accepted. So it is, again, imperative to ensure you're keeping this document up to date. But it is also imperative that you have a comprehensive durable power of attorney. With all of estate planning, you can find the cheap, easy, free tools online that look on their face like they will check the box for, now I have a trust, or now I have a power of attorney. But most of the time, in fact, I would pretty much argue all of the time, free equals simple. Free equals quality has had to be cut. One of the biggest things in a power of attorney that is imperative to have is a power in there that allows somebody, in the event of your incapacity, to set up advanced and additional planning on your behalf to protect you and your assets. So let's say there's an example where you don't need the OBRA 93 today. You come in and talk to us. You say, I'm not at the point of needing it, so I'm going to push it off. And a few years goes by, and unfortunately, you end up having a stroke, completely unexpected, and you lose all competency. Well, with a valid, comprehensive power of attorney for finance, it should then include a power that allows the person you have as a representative to set that planning up for you. Because now you've had a stroke, you have lost the control of half of your body, you're now in need of advanced care. Well, now those bills go up astronomically. So now is the time your loved one, your representative, comes in and says, what are my options? We don't have a ton of finances to just keep shelling out every month. So what can we do? Well, again, with a comprehensive, up-to-date, valid power of attorney, they could still go forward with an OBRA 93, protect any income that we're able to protect, and have you qualified for Medi-Cal so that they would cover or at least pick up a large portion of your advanced care cost needs. So again, it is imperative that you have this up-to-date, valid, current. Pause for 1 second for a question. So the question that we have, it's a little bit comprehensive. So my strong recommendation is set up a consultation with us. It can be just a phone call if that is easier for you. But if you already have a revocable trust and power of attorney, we would need something. Well, if you want the OBRA 93 trust, that's a separate trust. If you have a power of attorney done by Koppenberger within the last 5 years, you don't need a new one to accomplish what I am talking about. For the other questions, again, I would recommend setting up a consultation. Now, the other power of attorney that is imperative to have is an up-to-date healthcare directive. Now, to some extent, this is separate from the Medi-Cal trust because the power of attorney for medical doesn't dictate whether somebody can set up an OBRA 93 trust or not. But anytime we're talking about individuals over 18, we want to hammer home that you need to have an advanced healthcare directive that was done after 2004. If you have a healthcare directive, but it was done pre-2004, it is unfortunately no longer valid because HIPAA laws have changed, well, did change almost 21 now years ago. It's also, though, imperative that when we're talking about capacity, if you have lost the capacity to make your medical decisions, again, you want to make sure that you have a comprehensive healthcare directive. Some of those free and simple ones don't answer some of these fundamental questions that most people want to have made the decision on ahead of time. For example, life support or facility care. Do you want facility care or not? So the simpler the document, the more risk there is that you have cut out something that would have provided a fundamental need had it been in there to begin with. So just really quickly, just a couple of case studies. So let's take James. He comes in and he says, hey, I have income that I would like to see if we can protect it. I have Parkinson's. It's becoming more advanced. I know that I'm going to end up needing advanced care. Is there anything I can do? Unfortunately, if his entire income is $2,300 and it all comes from Social Security, he has unprotectable income as far as the OBRA 93 trust is concerned. So if he was to qualify just with this basic fact pattern, he would look at $1,700 per month as his share of costs. Now, that doesn't mean that James should not still attempt to qualify for Medi-Cal on the need of the physical side of it. Because, as a lot of people unfortunately know, California is not cheap and advanced care is absolutely not cheap. A lot of times for advanced care, the bills can be $10,000 and over every single month. So even if his share of costs is $1,700, if his total monthly bill is $10,000, he absolutely would still want to consider qualifying for Medi-Cal because they would pick up a lion's share then of what his monthly expenses would be just to take care of himself in a facility. So with that, even if the OBRA 93 trust is not the path that we end up recommending you take, or it doesn't make sense for you to take, our firm is still able to help you qualify for Medi-Cal. We work with a Medi-Cal specialist where we can act as the intermediary to gather data and make sure that you have a support system so that the qualification happens precisely rather than you having to potentially go back and forth, risk a rejection where you have to then appeal and try to requalify. So again, even if you have unprotectable income when it comes to the trust, still come and talk to us if you are concerned or considering qualifying for Medi-Cal. Now, in Maria's case, she has $2,100 of income. Only $600 of that comes from Social Security. The rest of it comes from her rental income. So again, the rental income can be protected, which means her income as far as Medi-Cal is concerned is only $600. So she then has no share of costs. She's able to keep all of her income and then qualify for Medi-Cal and have them pick up the entirety of the bill assuming that that's the plan she's under, rather than having any share of costs, which she would have had she not had an over 93 trust. So this is a situation that absolutely an over 93 would be imperative to make sure she's not losing all of her income at that point, but can truly qualify for Medi-Cal in its entirety. So again, the Medi-Cal asset test is gone, but they will absolutely still look at your income. So if you have any questions, if you are concerned about what does Medi-Cal now mean for you, maybe you have a parent or another loved one who you weren't sure what options you had or were prior told you have no options, come in and speak with us. By watching this education event today, you actually are then entitled to a free consultation to discuss Medi-Cal or your other revocable or power of attorney needs as well. So please take advantage of that. Please feel free to share this afterwards. We will have the recording posted to our YouTube page. And if you have any additional questions, you can, of course, reach out to us. Now, Medi-Cal, again, is a complicated topic if you're trying to do it alone. Our goal here is to help make it accessible, understandable, and frankly, ascertainable for those who may not think it otherwise was. A lot of times when we are in the position of needing Medi-Cal, we're already in a more vulnerable state. And now some people are very fortunate to have a team around them that can help them start to finish. But most people are not in that position. And so Kopenberger is here to help be that team and make sure that things are done right the first time and get you the care, help, and coverage that we are able to help provide. So thank you for spending some time with us. I know this wasn't extremely long, but it does again allow us the time to educate you on what has changed with Medi-Cal and give you that access to us. One question that I did just get is, how is the rental income protected by the trust? We essentially would then, we would set up the trust. We put the rental property into this OBRA 93, which means the income belongs to the OBRA 93 trust, excluding it from qualification consideration by Medi-Cal. Okay. I will be sticking around for a little bit, so if there are any other questions, please feel free to put them into the chat or the Q&A. If they're more specific, please feel free to use any of the information that is on the screen, and we look forward to working with you. Thank you guys so much. One question is, can I put income property into an LLC? You can for different protection reasons, but it wouldn't necessarily and most likely would not protect it from Medi-Cal qualification consideration. So that would be extremely important to discuss, and we have our LLC team that could be included in that discussion as well. For the what other income can be protected, so one of the prior slides, essentially, it said that everything except retirement income can be protected. Retirement income, though, unfortunately, cannot be transferred into an OBRA 93, so the retirement income is an unprotectable income source. To receive Medi-Cal, must one be in a Medi-Cal approved facility? So yes, the facility that you're in has to accept Medi-Cal payments. So there's two schools of thought. There's Medi-Cal approved facilities where Medi-Cal has said, yes, this is one of our facilities, but there are also facilities that will accept a certain number of Medi-Cal patients. So you actually, it's a little bit of a two-side there. Roth IRA distributions, anything retirement that is a required minimum distribution is considered income. Now, if it is not a required minimum distribution, that's where we begin discussing, do you have to take the additional income, or does it make sense to stop taking that income in order to qualify for Medi-Cal? If you turn your primary residence into a rental property and you're now producing income off of it, absolutely, we'd want to talk about an OBRA 93 to protect that income source. Investment income is protectable. So if you have just regular investment accounts like brokerage accounts, that income can be protected in the OBRA 93. So for 401ks that were rolled over, so what some people will do is essentially accept the penalty, move the account completely into, for example, an investment account, and then have that as a protectable source. But anytime you're changing the retirement in its entirety, there can be concern about taxable events, essentially. So that is going to be one, absolutely set up a consultation, and we would also pull in a financial advisor to assist in that conversation. So moving your retirement just into another account, people do it, but it's not always in their best interest when again we're looking at taxes, things like that. One of the questions in the Q&A, I'm not 100% understanding. If you're not using, it says IRS or Roth, are they counted as income? I don't know if that was supposed to be IRA. But again, non-retirement income, we can have that as a protected source of income. Retirement, required minimum distributions, or pensions, Social Security, that is unprotectable income. Now, if I wasn't fully understanding that, please feel free to reach out to us and we can set up a time to dive into it more deeply. Oh, that's a great question. So talking about government recovery, so this is a actually positive answer. If you have a revocable trust, just any revocable trust, and your assets are in that revocable trust, if you end up on Medi-Cal, whether you have the OBRA 93 or not, and you end up using Medi-Cal benefits and ultimately pass away, your assets that are in that revocable trust cannot be taken in government recovery after you are gone. So that is a huge advantage of having a revocable trust in place to make sure that, again, if you do end up with Medi-Cal benefits, they can't come after your estate after you've passed. The Roth IRA distributions, again, the biggest thing we're looking at is it a required minimum distribution? That's what it's going to come down to. If it's not a required minimum distribution, then it doesn't have to be forced, and we discuss not taking income out of those sources. The reason retirement cannot be put into the OBRA 93, so that's when I'm saying unprotectable, I'm talking about that trust. If you change the owner of a retirement account, any taxable consequence would be due at that point. Now, Roths have exceptions, obviously, to that. So that's where I'm saying anything with a required minimum distribution is what we are concerned about. And the same with how our inherited IRA is handled. If you have an inherited IRA that has required minimum distributions, that would be counted as income that cannot be protected under the OBRA 93. So if your rental property is in an OBRA 93, you do still have access to that income. So the OBRA 93 that we do at Kopenberger is a revocable trust. So you still have access to it, but we do talk about how best to use that income. So there's a big difference between using it to pay for expenses versus taking it out and putting it now into an account in your own name. That's a much more complicated conversation, though. So again, if you have more question on that, do set up a time to talk. For the look back period question, I would want to have a more individualized conversation. I may not be fully understanding what the question is in regards to the OBRA 93. So that would be one to reach out to set up a time to speak with one of our attorneys. For those of you still on the call, we've put up a survey. Also, if you're able to help us answer a few questions and let us know how we did, that would be great as well. To clarify, 401k accounts, we cannot protect them in the OBRA 93. Yeah, it's unfortunately a big source of where people do get their income. But again, depending on what your income is per month, even if you are over the limit, Medi-Cal still can kick in and qualify. You just end up with that share of costs. So it doesn't mean that you're completely barred, but it means that you would have some money you'd have to put up before it would kick in. So again, from a qualification standpoint, you can come in and talk to us. All right, so I am going to sign off at this point, but please, again, if you have any additional questions, feel free to write into us, make an appointment. As I mentioned, because you are attending this webinar, you are entitled to that consultation if you have not already used your education consultation this year. You are welcome to speak with me directly or any of the attorneys on our team. So if you have already worked with, for example, Larry Kopenberger, you are welcome to speak with him as well. But we look forward to working with you and answering any additional questions that you guys have. Thank you so much for being here. It was wonderful to get to spend some of the afternoon together.